Greetings and welcome to today's webinar. It is great to have you here. My name is Tanya Frazier and I will be your IAAC webinar monitor. Today's webinar is a part of a webinar series offered by IAAC, and I invite you to visit our website and to check out a few of the recordings of recent topics, such as understanding impact assessment, species environmental assessment, air quality, microplastics, and many more. If you would click the next slide there, please. You can see that the website available for you to access those is www.iai.org/webinars and .php at the end. You can find that also by just going to the IAI webinar or IAI webpage, and navigating through. Finally, as you are watching the webinar today, if you're having things that you'd like to share in social media, feel free to use the @IAIA network handle or the hashtag IAIA webinar. Just a few housekeeping pieces of information for you as we proceed today. You have a control panel that you are able to access during the presentation. On the very top of that control panel, you will see a red or orange arrow. That arrow will take the control panel off of your screen and bring it back onto your screen. So you can take it and hide it during the presentation so that you can see the full slide in full screen mode. This presentation is being recorded and will be made available to you via email. After the presentation, it will be 24 to 48 hours after you will get the email with not only the presentation, but also access to a copy of the slides. This is a 90-minute webinar today with 4 different presentations and then time for questions. Please enter your questions at any time under the control panel in the questions section. And they will be moderated. We will not be taking pauses during the presentation to answer questions individually. There will be a question and answer section at the end, and we will do our best to answer as many of those questions as we can. Also, finally, we will, there will be handouts available for you if you're a visual learner in this moment. The handouts of the slides are available for you to print out right now in the handout section in the control panel. Today's webinar is on compliance with and enforcement of EsIA requirements, commitments, and permits. It is being organized by Cheryl Wasserman, Chair of the IAI Special Interest Section on Governance and Implementation Systems. It is also co-sponsored with the International Network on Environmental Compliance and Enforcement, or INES. Cheryl will be facilitating our discussion today, and more information about this section will be available in the follow-up handouts that will be emailed to you. At this point, I will turn it over to Cheryl Wasserman to get us started. Have fun, folks.
Cheryl, just so you're aware, you're still muted.
Thank you to my colleagues who told me that I was still muted. Hello, everybody. Hello, my colleagues, my dear colleagues. Thank you, Tanya and IAIA, for your support to help us advance the impactfulness of impact assessment as one essential element of any successful environmental governance program. We're very pleased to have robust participation of hundreds of participants from all corners of the globe, and may you stay safe in this time of pandemic. As Tanya mentioned, this webinar is hosted by IAIA's Governance and Implementation section. The section is currently focused on 2 issues. The webinar we hosted in March of 2018 addressed government reform efforts to achieve greater efficiency and effectiveness. El Salvador was our case study. A recording and handouts are on the IAAA website. Our second area of focus is the subject of this webinar, compliance and enforcement for environmental and social impact assessment. Our work complements a series of webinars that our co-sponsor, INES, the International Network for Environmental Compliance and Enforcement, held in 2018 with the Inter-American Development Bank, IADB, along with current series of webinars on enforcement of permits, which now also includes Red La Fica as a host. That's Latin American Regional Network on Environmental Control and Compliance. Information on those offerings are on the slide at the end of the PowerPoint presentation for your reference. Compliance and enforcement also is a session topic that will be addressed in IAAA 2021 conference in Seville. That session will be moderated by Christian Perez, ECOS in Chile, and myself, so please submit papers on this topic. Some of you already have. Finally, we are preparing an IAAA best practices document on compliance and enforcement of ESIA. Next slide, please. This slide includes both a generalized outline of the ESIA process and the established framework for compliance and enforcement. Our first draft best practices paper begins to align the compliance and enforcement framework with each step in the ESIA process, but we still must add examples as well as work the other way around. Please help us develop these best practice principles and examples. A quick side note that we will be using some terms interchangeably, all meeting the broad scope of impact assessment, whether we say environmental impact assessment, environmental and social impact assessment, or ESIA, EIA, IA. They're all meaning the same. Before we begin, I want to leave you with 3 messages. First, solutions to the compliance and enforcement challenge permeate the entire ESIA process, not just the end of the process. From the requirements for environmental review and levels of review through to legally binding commitments for approval. Next slide, please. A second message I leave you with is that government programs are under tremendous pressure from investors, donors, the public to implement ESIA processes to address a wide range of issues covering the natural, biological, and physical, from natural hazards to ecosystem protection, and human, socioeconomic, cultural, health, protecting vulnerable populations, i.e. environmental justice, environmental concerns. Next slide, please. The breadth of issues and institutions involved is a challenge in itself for decision makers, but even more so for follow-up monitoring and compliance assurance with those commitments to mitigation and conditions for project approval. The bottom line, however, is that nothing we do as ESIA professionals is real unless there are commitments met and promised results achieved. Next slide, please. Next slide. Compliance enforcement follow-through is perhaps the biggest impediment to achieving positive results from the ESIA process, and that touches on the ESIA process in its entirety. So, next slide, please. We will now hear unique perspectives on compliance and enforcement of ESIA from 4 outstanding professionals from around the globe. The government of Chile has a single institution, a superintendencia, responsible for all environmental compliance across organizations at the national level, including that responsible for ESIA. The superintendencia has created an intelligence unit that integrates data management with strategic planning and follow-up. Sebastian Elgueta will be presenting that experience. Phil Seeto heads the recently created Compliance Enforcement and Follow-up Unit within the Impact Assessment Agency of Canada as part of a larger effort to enhance enforcement and follow-up authority for the IAAC, renamed in the process of reform from what you might already know as CEAA. Phil has had many years of experience in the environmental impact assessment, development, and review side, and now focuses on enforcement. But in contrast to Sebastian, his position is within the institution responsible for environmental impact assessment. Erica van den Honert, Australia's New South Wales presenter, has sat in both seats, environmental and social impact assessment and then enforcement, both in the private and public sectors, and now works in the post-approval space, making sure that conditions of approval placed on infrastructure projects and the commitments and mitigation measures made in EsIA are carried forward into project delivery. So she also brings the unique perspective of having moved between the two functions. Finally, we will hear from Matthew Baird, Director of the Asia Research Institute for Environmental Law, and who, as a leading consultant and lawyer in the region, has had a clear view of the experiences of Southeast Asian countries as they have tried to enforce EsIA requirements, develop and implement new laws. Next slide. We have allocated our 90-minute webinar, roughly as noted in the slide, to balance presentation time with discussion amongst panelists and respond to participant questions and comments. We are preparing a report on the webinar. If we don't get to all the participant questions and comments during this session, we will be certain to respond in the report. As you listen to these presentations, I encourage you to think about lessons we can learn from this and other relevant experiences you as participants can offer. Next slide. So with that brief overview, it is my pleasure to introduce our first presenter, Sebastian, Director of Chile's Intelligence Unit. No doubt we can all use more intelligence. What does it mean that the Environmental Superintendencia, SMA for its Spanish acronym, is the institution in charge of environmental enforcement and compliance in Chile for all environmental programs, not just EsIA? You can imagine the challenge for follow-up and monitoring when there are more than 15,000 environmental licenses approved in Chile with different formats, requirements, and commitments. We will hear about a digital transformation strategy to include advanced monitoring techniques, electronic reporting, transparency of compliance data, and use of predictive analytics to automate and improve compliance verification. An open and constantly updated environmental baseline also can feed back to science and decision-making processes, including environmental impact assessment. So how is this capability and the cross-cutting nature of the institutional arrangement for follow-up monitoring and enforcement affected EsIA? Let's hear. Sebastian, I turn to you.
Thank you very much, Cheryl. Well, it's okay. Well, I'm going to present you our experience about enforcing EIA requirements in Chile. First of all, a brief introduction. Well, Chile is a South American country. We have different landscape and ecosystems that we want to protect, including deserts, Andes Range, and rainforest. Our main exports are copper, fish, fruits, paper pulp, and wine, so you can have an idea about the pressures and the impact that we have to deal with. Since 2010, we have 4 environmental institutions in Chile: the Ministry of Environment, which is in charge of the policies and regulation; the Environmental Impact Assessment Service for approval of the permits; the Superintendents for the Environment. We are in charge of the enforcement and compliance; and finally, the Environmental Courts for resolving controversies about our decisions and resolutions. So for compliance and enforcement, we do basically a different kind of activities, including monitoring, assistance, compliance, supporting, public information, sanctions, and penalties, such as closures, permit revocation, and fine up to $8 million for each violation. So it was a huge change. We need we have to monitor everything, no? All kind of environmental regulations. We have almost 16,000 environmental permits, which come from the EIA processes. We also have emission standards, decontamination plans, quality standards, compliance program, green taxes law, extended producer responsibility law. So you can imagine that the challenge is huge. We have to monitor and enforce the compliance from more than 16,000 facilities, from big companies to small ones, in all our territory. Now you can see there in the image, some of these facilities have to comply more than one regulation, and even some of them have to comply more than one permit. No, that is really complicated for the monitoring team. No, for big projects such as a mining copper project, sometimes they have 10 or even more environmental permits, and they could be inconsistent each other. So it's evident that we need technology, we need data. We are only 250 people in the institution, so we had many problems at the beginning during the first year. So 5 years ago, we started a digital transformation path through a strategy called Environmental Compliance 2.0. We took the idea from the next generation compliance approach promoted by US EPA. This has 5 components: advanced monitoring, electronic reporting, transparency of the information, innovative enforcement in real cases, and the influence of the technologies in the new regulation design. We need more data, we need more technologies. After 4 years of this strategy, we have developed an electronic platform which is conformed by different integrated systems. No? Each circle in the image corresponds to an information system that cover a specific business process. So we have systems for internal management, for technical entities, for public institutions to share information. And you can see all the green ones are for electronic reporting from regulated entities. Most of them are collecting raw data, but some of them are collecting digital documents. That is the case of the for EIA requirement and commitments reporting. We are collecting a lot of documents for that, so we have a project about it. I'm going to tell you about it later. All these systems are integrated through the CUF that you see in the center of the image. That means that we have only one register for each facility, and all the systems consume the same basic information. Part of this information is shared in our environmental compliance national system. It's public information. We call it SNIFA. We have more than 1 million of visits per year. There you can find information about our procedures, enforcement cases, sanction penalties, and also all the reportings from regulated entities, including data and reports. We also have developed capabilities about advanced monitoring and analytics. For this, we use real-time monitoring, the concept, the Internet of Things concept, satellite imagery. We use optic and radar images, and we also use drones. We have a thermal camera to identify emissions. So after this first stage, we have developed descriptive and diagnostic analytics capabilities. That means that we are taking data from the past to solve questions such as what happened, why did it happen, thanks to our environmental compliance digital transformation strategy. But now we need to look forwards. We need to develop abilities for predictive and prescriptive analytics. That means to solve questions about the future, to take better to take better decisions. And for this, we are just launching our new strategy called environmental intelligence for the next 4 years. And this is based on artificial intelligence techniques. This slide summarizes the idea. We are collecting at this moment a lot of data from different sources through our electronic reporting systems, but now we need to process this data using big data, machine learning, artificial intelligence, and data science techniques. For what? To get indicators, to know about the state of the environment, because this is the only way to attain a timely, effective, and efficient response. We need to be faster. We need to be proactive. If we identify some deviation early, we have to take actions about it. So now I'm going to tell you about what we are doing for enforcing EIA requirements specifically. We want to get this virtuous circle, the traditional path. Permits go from the EIA team to the enforcement team, but there are few chances for to get feedback. No, we need feedback, and that means data, information between both teams to improve what we are doing. So, of course, we have many difficulties for enforcing these requirements in Chile, and this is kind of non-wish list, probably pretty similar than you have in your countries. Our EIA documents are too large, massive, and sometimes 100 or even 1,000 of pages. Non-standardized formats for documents and for requirements. Some requirements are beyond environmental matters. We have many facilities with more than one permit, as I told you, and they are inconsistent each other in some occasions. And it's not easy to update permits. They last almost forever. I mean, they include the different phases of a project, such as construction, development, and closure. But if it's necessary to identify important, significant modifications of the project, or even for the parameters, indicators. So it's not easy to update them. We have limited staff and budget. I told you that we are only 250 persons, and we still have information silos and lack of data. At this moment, we have different platforms without disaggregated data. The EIA team manage information, and the enforcement team manage different information, but this is complementary. No, it should be the same platform. Our current system, what we are using to collect all these reports is, you can see there, we have at this moment thousands of PDF reports that include millions of data. We have received more than 80,000 reports since 2013. We are collecting some general data, metadata, but we need raw data. You can see there a typical report. This is an example for sand crab, a monitoring study. A lot of information in this document. So I think we have two very important questions. The first one, are EIA requirements and commitments being met? Probably not. Actually, in our case, we have monitored only 1/4 of the old permits. So we have a lot to do. But the second one is very important, because if we have full, total compliance, is enough to ensure environmental protection? Probably not, because EIA process don't include everything. No, probably there are some parameters, indicators that that are not included in these processes. So we need more data and we need analytics abilities to deal with this. We are designing a new information system. The idea is to go from PDF reports to data reporting to collect all kinds of parameters in raw data, I mean. So we will have an environmental baseline available for anyone, science, public institution, investors, citizenship. This is the idea. We need a unique platform with disaggregated data to share information between both teams, EIA team and enforcing team, with baseline and monitoring and follow-up details. Some aspect of our project, we are including the register of requirements and commitment. Companies have to do that. Standardized report formats for each component, automated compliance verification. If we have the two registers and standardized reports formats, we can automate all the process. We will develop environmental indicators and predictive models with all this data, and we will develop a portal for regulated entities because we want to support the compliance, and portal for citizenship, open data, and APIs for developers and academics. And very important, probably during the next year, we will launch a reporting using APIs, machine-to-machine concept. We need to integrate machines because companies already are using our own software to collect all the information, so we need to integrate these systems. We are using the agile development, and this system is oriented to live in the cloud and for big data. You can see as well some of data to be collected, component, coordinates, dates, parameters, values, units, and so on. At this moment, the format for water component is already working. Companies are using this to report us data, and we hope to launch this new system, at least the first version, during the next month. This is what we want to do about portals. During the next year, we should launch these portals with data, indicators, and predictions. We want to support, we want to facilitate the compliance, and for that, companies, facilities need this kind of information. It's not enough to know if they are just compliant. What is going on in their territories is very important. Additionally, we're using other applications for enforcing EIA requirements and commitment. For example, you can see here, we are using satellite imagery to do a massive monitoring of more than 5,000 wetlands. This is automated process. We use pre-detection of vegetation index, optical satellite images, so we know what highland wetlands have problems at this moment. The same idea, very similar for fish farmings. We have thousands of fish farms in the south of Chile, and we are using automated algorithms to check if they are compliant with the permitted location. And for this, we use radar, satellite images, cloud computing, and it has a dissociative effect very, very clear. You can see there the compliance of a specific fish farms after some years. And finally, the last one, we are promoting real-time monitoring, because many permits require continuous monitoring. Now that is in the document, so let's connect. That's the idea. That this includes continuous emission monitoring systems, air quality and water quality monitoring stations, and some operational variables. So we're using API to do this, and it's very fast and cheap. Of course, we need cloud computing services and cloud to do this because it's a lot of data, but we will have thousands of facilities connected during the next year. So this is the future. We need real-time data to make better decisions. So a final thought, I would say that there are 4 key components for a digital transformation strategy. First of all, institutional commitment. Then governance, that means procedures, processes, and skilled people. No, it's necessary a lot of training in these matters. And finally, the access to technologies, no, mainly cloud computing services and high computing capabilities. So I would say that digital transformation is not only about technology. First of all, it's about people, culture change. It's a transformation. And then it comes the technology and digital part. Thank you very much. Now it's time for Phil. Phil Seeto, who will advise us about Canada's experience with monitoring, compliance, and follow-up of EIA. Phil heads the new unit in Canada's EIA institution to carry out this very function. Is focused mainly on, exclusively on EIA and within that institution. Please, Phil.
Thank you very much, Sebastian. I thoroughly enjoyed your presentation, and I look forward to the discussion at the tail end of this webinar. You can go to the next slide there, Sebastian, please. Good day all, my name is Phil Seeto, and I'm very excited to be here, joining this group of engaging and highly knowledgeable experts in the field of ESIA, compliance and enforcement. I've been working with the Impact Assessment Agency of Canada, formerly the Canadian Environmental Assessment Agency, as some of you may have known us as, since 2010 in various roles. Presently, I'm the Director of Compliance, Enforcement and Follow-up, and have been asked to speak to recent changes made to the EIA process in Canada. Next slide, Sebastian. Sorry, if you go back one there, please. This is my first experience with IAAC, and I hope you all find the information that we are sharing with you enlightening and useful for the work you are doing all over the world. On August 28, 2019, new legislation came into force in Canada, the Impact Assessment Act, which then resulted in the change of our name as well. That changed the way proponents and projects in Canada are regulated. This was the culmination of approximately 3 years of work done to improve the EIA system in Canada, mainly for these reasons: increased transparency and certainty through the use of robust science, evidence, and Indigenous knowledge, greater opportunities for meaningful participation by Indigenous peoples in the public, more Indigenous leadership opportunities and partnerships, inclusion of health, social, and economic considerations instead of just the environment, more coordination with provinces to support the one project, one assessment approach and avoid duplication, as well as more predictable and consistent timelines. Next slide, please. With the new legislation, there are now 5 phases in our IA process. This includes planning, as you can see on the screen, impact statement, the impact assessment phase, the decision-making phase, and finally the post-decision phase. And it's the post-decision phase where the magic happens, or let's just call it that. This is where the topic of this webinar connects. So within the post-decision phase are all activities following the issuance of our decision document, which we call the decision statement, the approval. This phase is designed to strengthen follow-up and compliance, implement information requirements and timelines outlined in the conditions that are part of the decision statement, make records relating to the design and implementation of follow-up and the compliance program publicly available, provide opportunities for community participation in post-decision activities, and the ability to even amend conditions when necessary in a decision statement. So the objectives of this phase are to strengthen follow-up and compliance, as I listed, and those items on the screen. Sorry, that I just mentioned, none on the screen, apologies. So the main key feature as it relates to this webinar is strengthen monitoring, follow-up, and enforcement. Next slide, please. So the general application of compliance, promotion, and enforcement remains the same for us here in Canada. And our approach is to still promote compliance throughout the process, which is our ultimate goal. We're not looking to find every single non-compliance. It's really to bring proponents back into compliance and ensure that any impacts are mitigated as quickly as possible. I've highlighted here on the screen 3 of the major changes that have come with the new legislation in Canada. The first, non-enforceability for projects where lifecycle regulators adopt conditions into their permits, certificates, authorizations, approvals, etc. These lifecycle regulators include in Canada the Nuclear Safety Commission, manages the nuclear projects, the Canadian Energy Regulator, which handles pipelines, for instance, as an example, the Offshore Petroleum Boards, which regulate exploration and development projects for oil and gas in the Atlantic Ocean off the east coast of Canada. The main reason for this is to provide proponents and the public with one point of contact and predictability. The assessment is still completed by our agency, but when a positive decision is made for a project to proceed, it is then the life cycle regulator that will verify compliance and take enforcement measures as needed. This cuts down on having 2 regulatory bodies conducting site visits, requiring information, and it reduces the duplication of work by project proponents. The second change, as you can see on the screen, are stronger tools in cases of non-compliance. These include, but are not limited to, I've just highlighted 3 here that I thought were the most important to highlight. Increased fines, up to $8 million. That's right, $8 million. This would be for a second or subsequent offense by a corporation or an entity that commits an offense under the legislation. I must admit, we have yet to levy a fine to a proponent to date of this magnitude, but this is proponents recognizing that not complying with conditions can have some pretty hefty, pretty serious consequences. The next one listed there is immunity. And so whistleblower protection, so to speak, and this protects our enforcement officers and our analysts and anyone working with our powers and duties or functions under our legislation. This needs to be done in good faith, of course, but this could include either actions they take or actions that they don't take. So it protects them, allows them to do their work without fear of repercussions. Then the third item I've listed there under number 2 are publication powers, meaning that we must publish information provided by proponents to comply with conditions. Summaries of reports that are completed by enforcement officers in the exercise of their power, duties, or functions. A notice of non-compliance, where a proponent has been informed of such, and a written order when issued to a proponent. This new requirement gives the work we do much more visibility and ensures that proponents are aware that their actions and inactions will be documented and shared publicly. This meets the improvement to our legislation, or the intended improvement to our legislation, of increased transparency and certainty through the use of robust science, evidence, and Indigenous knowledge. And now to the third point up there, and the third big change. I'd like to highlight this one. It's one of the teams that I manage, and that's the creation of a follow-up team. It's the one I'm most excited about. This unit was created with a goal of verifying that mitigation measures are effective and that the predictions of the assessment are accurate and proponents are actually achieving what they assumed they would. One of the purposes of this new legislation, as I talked about at the beginning, is to encourage improvements to impact assessments through the use of follow-up programs. And so it's important to note that the creation of the follow-up team comes from funding that was provided to us for the implementation of our new legislation, the Impact Assessment Act. Follow-up has always been in the federal legislation, but this is the first time that funding has been provided to track and report on project follow-up programs. As I like to say, the compliance and enforcement team was the flagship addition to our agency in 2012 with the new legislation that was brought in then. I feel that the follow-up team is much the same this time around. Prior to our previous legislation, proponents were issued their decision statements and they could walk away and never held accountable necessarily. The creation of the compliance and enforcement team changed that and showed proponents that they need to stick to their commitments and build projects the way they were assessed. Now, with the creation of the follow-up team, as a result of those funds from our new legislation, we are diving even deeper and not just making sure that proponents are doing what they were told to do, but that in fact those measures are working as we were told they would, or as we expect them to. Another responsibility of the follow-up team is to establish monitoring committees for projects where there may be uncertainty or questions, including in the mitigation measures being proposed, the science being used, or even the type of project and components that are being proposed. These monitoring committees are an important tool to provide oversight and guidance on the requirements set out in the proponent's follow-up and monitoring program. Monitoring committees can also help provide additional confidence in the science, Indigenous knowledge, and other forms of evidence used in the follow-up and monitoring programs, ultimately leading to greater public trust in the assessment process. The creation of the follow-up team has helped with the goals, as I mentioned earlier, of increased transparency and certainty through the use of robust science, evidence, and Indigenous knowledge, greater opportunities for meaningful participation by Indigenous peoples in the public. These monitoring committees can be made up of various parties, provincial entities, federal entities, NGOs, non-government organizations, Indigenous peoples, and even the public or public groups, as well as more Indigenous leadership opportunities and partnerships. Next slide, please, Sebastian. So what does this all mean? Well, we're still in infancy of this new legislation. It hasn't even been a year since it came into force, but we've already noticed slight changes to not just the work we are doing, but also the ways in which proponents, Indigenous groups, and the public are engaging in these assessments. Ultimately, what we hope this will accomplish includes productive relationships with proponents where they feel they have a thorough understanding of their requirements and commitments, and are therefore more open to meeting with the agency and engaging in our process. As I'm sure you'd all agree, having a willing proponent makes a huge difference. It also ensures that the focus on compliance, promotion, and education, as opposed to just taking enforcement actions. Our primary goal is bringing proponents back into compliance and to stop whatever impact that may be happening. And these added requirements and tools that I've explained are already starting to show their value. The new legislation provides for fair and transparent actions taken by the government and proponents, which is a win for all parties involved. And finally, all of these changes lead to the greatest goal and soon to be accomplishment of this legislation. It creates accountability in the IA process to build public trust and confidence in our process, where the public, Indigenous groups, and stakeholders feel that their interests have been considered, applied, and being followed through on. Thank you. That concludes my portion of the webinar. And now I would like to hand over to Erica van den Honert, who works for the New South Wales state government in Australia, where she works to ensure that documents required by the conditions of approval on major infrastructure projects comply with the conditions. Prior to this, Eric worked as a consultant preparing environmental impacts assessments, construction management plans, and on-site compliance and on construction sites in South Africa and Australia. Over to you, Erica.
Thank you very much. So I find it very interesting, the parallels between Canada and the issues that you are facing and what's happening here in New South Wales. Good evening, everyone, and thank you for joining us on this panel discussion. I'm going to talk to you today from the perspective of having worked in South Africa and New South Wales, in Australia, and as Cheryl said, in the impact assessment and post-approval space. I'm going to provide you with an overview of the system in New South Wales and then share some key messages and discussion points. Because terminology is very different around the world and can be confusing, as Cheryl pointed out, I'd like to just clarify that when I talk about EIA, I am referring to the process up to the point where a decision is made on whether or not to proceed with a project. Once that decision is taken, we enter what I call the post-approval phase, which generally comprises detailed design, construction, and operation, and of course includes then compliance and enforcement. Next slide, please, Sebastian. There are about 8 approval pathways governing development in New South Wales, but today I'm only going to talk about major infrastructure projects that are decided by the New South Wales Minister or his delegates in the Department of Planning, Industry and Environment. The legislation governing how EIA is undertaken in New South Wales is the Environment Planning and Assessment Act. When projects are approved, it is always with conditions, and proponents are responsible for complying with these conditions. The department's focus is to promote constructive engagement and to monitor and enforce compliance where necessary, which is a focus that aligns closely with Canada's goals and the way you operate there. New South Wales also has an Environment Protection Agency, or EPA, which is responsible for enforcing the Protection of the Environment Operations Act. This act deals with pollution of the environment, for example, air, soil contamination, water. Certain projects and activities require licenses or EPLs, which set pollution limits on projects during construction and operation. For example, sewage treatment plants have operating licenses that control the quality of water discharged to the environment. So as you have, and as Sebastian mentioned, you do have projects that have both covered by conditions of approval and have got EPLs. And the two of those obviously need to align in an environment where an EPL can change, but the conditions of approval don't. Both the department and the EPA have the ability to undertake formal action, which includes imposing fines for non-compliance with the conditions or breaches of the POEO Act or license limits. Next slide, please, Sebastian. Oh, can you go back one, please? That one. Thank you. This slide provides an overview of the EIA process in New South Wales. There are additional steps, for example, the process of modifying a project, changing the conditions, as well as Phil mentioned, but as you can see, the process is very similar to that of other countries. I was interested in Sebastian's comments that EIA documents are too large. It's not unique to Chile. In New South Wales, there's been lots of discussion on how to reduce the volume and complexity of documents. This was also a major topic of discussion at the last two IAAC conferences. It's an important one, but not for today. I also look forward to more discussion on how we can move to a system that better captures all the data generated, both in EIA and post-approval, and allows it to be shared more broadly. And I hope that the work and the learnings from Chile can help all of us in this regard. Next slide, please. So as I mentioned, when projects are approved, they come with a set of conditions. There's always a condition that requires that the project is delivered in accordance with the EIA and the commitments it made. Conditions are generally either prescriptive, where the limits or the criteria are known, for example, the number of trees or buildings that can be knocked down, or management-based, where clear limits cannot be easily imposed, for example, construction noise, dust. These are generally managed then through management plans. There are two main mechanisms for reporting against conditions and commitments in the EIA: compliance reporting, which is a self-reporting mechanism, and independent auditing. And the reports which document the outcomes of both of these are submitted to the department in PDF form and may also be made public if required by the conditions. So interesting to see how Chile is going to capture all this information and make it data-based. In addition, projects that have licenses from the EPA have to report to that organization against their license conditions. So from a public's perspective, the dual reporting and regulatory function can be confusing. It also makes it hard to know which government agency to contact to report something. Next slide, please. This slide has got a lot of information on it, and I put it in so that when you get the handouts, you would have it at your disposal. It gives web links and useful sources of material for any of you who are interested in how we condition major projects in New South Wales and the post-approval guidance that is available. The indicative conditions for which you have the web link there have been written to provide clarity and enable enforcement. So for example, we've used words like must rather than should. There are always conditions that say that the mitigating measures and commitments in the EIA have to be complied with. And where documents have to be prepared, for example, a management plan, there are timing triggers associated with them. So for example, documents have to be prepared and submitted for approval before the activity commences and must be implemented for the duration of that activity. There's a strong focus in the conditions on transparency, with the requirement for documents to be made publicly available, and there are a range of conditions around interacting with the community and the public. The compliance reporting and independent auditing documents have very recently been updated to improve efficiency and streamline compliance reporting. And there's been a shift from independent to independent auditing rather than self-reporting. If you remember, I said at the beginning that compliance reporting was a self-reporting mechanism, in part because independent audit of a project is seen to provide a more accurate picture of the project's performance. However, there is also obviously the concern that auditors won't get accurate information if they don't ask the right questions, and therefore there may be gaps in the audit findings. Compliance reporting is very useful, but for it to reach its full potential, it needs to be an honest reflection of what is happening. And one of the main concerns about this form of reporting is that proponents won't report honestly because they are afraid it will result in enforcement action and fines when those reports land on the department's compliance team. My final slide, please, Sebastian. So what are my key learnings from years in this profession? First of all, and this also relates to a slide that Sebastian put up, getting the feedback loop from impact assessment to post-approval and back again is critically important to ensure that impact predictions and the mitigating measures in the impact assessment and the learnings from post-approval are fed back into the system. One of the challenges to achieving this is how we capture and share on a broad scale lessons learned from projects in a constructive way, and how we encourage those involved in post-approval to identify what went wrong and what they could have done differently without fear of enforcement action. And lastly, how and where we record this information so it's available to others. There's no doubt that conditions need to be written in a way that is unambiguous to ensure they can be enforced. Impact assessment and the identification of mitigating measures comes to little if conditions can't be enforced because of the way they are worded. And there needs to be an ability to fine proponents where all other avenues for achieving compliance fail. We all know that things change as projects progress through assessment and approval into delivery, and that constructors or operators may identify improvements in technology or methodology, and that the design changes through a project's life. And I think one of our challenges is how we build in flexibility while still ensuring compliance. Some of you may have views or experience in this issue. And lastly, and this is something that Phil has also raised, I think that building relationships and trust is critically important so that proponents are able to report accurately and honestly and without fear of unnecessarily harsh enforcement, so we can all learn. Next slide, please, Sebastian. And that is all from me. I'd now like to hand over to Matthew Baird, an environmental lawyer who's been advancing environment and social impact assessment law and practice both in Australia and Southeast Asia. Since 2010, Matthew's played a role in helping Cambodia and now Myanmar develop new legislation and processes in EsIA, tracking what they have explored as best practice in the country or as part of their regional networks, as well as trying to learn from each other and other countries outside the region. Thank you.
Thank you very much, Erica, and thanks to my former presenters. Can I have the next slide, please, Sebastian? Next slide, please. Thank you. So today I just wanted to start by talking about the Global Day of Action, which is a day from the International Trade Unions Council about climate and employment proofing our work, spurred perhaps by the two great issues that we are facing currently, notably climate change as well as the coronavirus. I thought it was also useful for us to then think about these issues as a reflection of the role that we see environmental impact assessment as playing in being able to identify key issues, both environmental and social issues, that are then addressed by project proponents and EIA consultants for both construction and the operation of the project, and indeed the final decommissioning or remediation of a project. Next slide, please. So I'm very happy to be able to share with you some of my experience over the last 10 years in both Cambodia and Myanmar. I've also been working with the ASEAN Intergovernmental Commission on Human Rights, looking at ways to make environmental impact assessment more responsive to the rights-based approach and some of the environmental justice issues. But one of the things that I learned from my experience in Cambodia and Myanmar is that there is a great deal of similarity between countries that have already had some environmental impact assessment, such as Cambodia, which started their EIA systems in 1996, and countries that have recently enacted legislation and procedures, such as Myanmar, that enacted their environmental impact assessment procedure in 2015. So when I first went into Cambodia and worked with Vishnu Law Group and His Excellency Dan Saray of the Environment Conservation of the EIA department in the Ministry of Environment in Cambodia, we did an assessment on the operations of 20 years of the Cambodian EIA experience. And we found that some of the key challenges were challenges that are well known to everyone working in EIA. There was a weakness in regulatory capacity. There were challenges in impartial enforcement. There was a significant lack of experience in the legal system. In 2012, there had yet been no pollution prosecution or prosecution for breaches of environmental impact assessment conditions. There was also no pollution permitting system in place. So the EIA system and approvals became very powerful because that was the document that created the obligations and the permitting. And there was no formal pollution permitting or facility permitting that most jurisdictions have also adopted. And while there were regular visits to facility sites, there was significant challenges with independent verification and testing. Next slide, please. So when we looked at drafting a new EIA system for Cambodia, the processes remained the same, fairly similar to all the processes that are used in EIA systems around the world. But we then looked at compliance and we asked, how do we frame compliance and enforcement? And up front was self-regulation. And again, we've heard some interesting ideas about how some jurisdictions are moving away from self-regulation. But within the Cambodian experience, and certainly in Myanmar at the moment, we're still looking at the role and importance of facilities and project proponents to regulate themselves with self-monitoring, self-reporting, but also with the need for regulatory follow-up. We then looked at compliance and looked at the idea of administrative orders, penalty notice, and suspension of activities. And then finally, looking at enforcement, civil actions, criminal actions, the loss of permissions as being the ultimate aspect of enforcement and compliance, but one of which we tried to avoid, hoping that we could bring facilities into compliance and avoid some of the environmental and social consequences of ongoing breaches of EIA approvals. Next slide, please. So, as I said, in Cambodia, under the leadership of the Director General of the EIA Department, His Excellency Dan Saray, we looked at drafting this EIA law, which ultimately morphed into a new draft Natural Resources and Environmental Code for Cambodia. And within this, we took a multi-pronged approach to enforcement and compliance. We added a separate title on environmental audits, monitoring and reporting, picking up a lot of the experience in Australia and Canada for the idea of environmental audits, and particularly independent audits with the power to make recommendations. There were requirements for reporting for holders of permits and approvals, the requirement to actually report to the ministry or the relevant government agency. We also focused heavily on public availability of information and, importantly, the role of public participation in the finalising of environmental management plans for Project EIA. We also sought to enhance EIA by making risk assessment a mandatory requirement for financial institutions that were going to lend for projects, which also included the financial institution had to make provision for adequate EIA being done and environmental management being included in the cost of the project. And finally, we looked at establishing a permit scheme for air pollution, water pollution, waste, hazardous substances. It was a significant undertaking by Cambodia. Next slide, please. We then focused in terms of enforcement. And again, the Cambodian court system had not had experience with a lot of enforcement. And a lot of enforcement in Cambodia was actually conducted at the commune level. the local level, which sought to resolve disputes in a very culturally appropriate way. So we tried to develop that as part of the enforcement and compliance system. We looked at administrative orders to give the regulator, in this case the EIA department, strong powers to require the production of permits, production of information, requiring them to comply with orders issued by the ministry to bring them into compliance. We also established a broad-based environment and natural resources mediation committee at the local, provincial and national level. There was the establishment of an environment and natural resources court to provide particular focus on civil and criminal jurisdiction. There was the inclusion of broad standing, the idea that any person could bring a complaint. It didn't go as far as protecting whistleblowers, a very important, I think, initiative from Canada. The focus in Cambodia was on the public engagement for reporting, so setting up national hotlines, including the community, which then, of course, would then activate the idea of community mediation. We also made it clear that a breach of a permit or an approval could lead to suspension of the project. The idea of halting the project until it came into compliance was deemed a very powerful message to send to project proponents. And ultimately, we also looked at the establishment of a process for restoration and compensation for environmental harm, following a lot of work that was done in the United States to create the idea for restoration if there was breaches. Next slide, please. And some of this experience in trying to frame dispute resolution and trying to frame compliance and enforcement for EIA approvals has then found its way into the Myanmar system. Myanmar established its environmental impact assessment procedure in 2015, and it has about 200 EIAs that it reviews every year. And again, with those EIAs, the final product of the EIA process is an environmental compliance certificate that contains a number of conditions of approval. And in Myanmar, like in Cambodia, there's currently no process for issuing pollution permits or permits that manage hazardous waste, except through this ECC. And so the environment compliance certificate has become, again, a very strong tool for environmental compliance enforcement. This year, under the leadership of the Director General of the Environment Compliance Department, Ula Mangthain, we are focusing very strongly on looking at how we can strengthen environmental compliance and enforcement. And so currently we're looking at the idea of including in environmental compliance conditions a number of very clear and specific requirements. Requirements for reporting, requirements also for insurance, bonds and financial guarantees, guarantees that could be accessed in the event of a breach that gives the department an opportunity to clean and to clear up aspects or pollution or incidences that occur if there is a breach. We've also made very strong commitment to community consultation. Every major project that requires an EIA or an initial environmental assessment examination is required to set up a project grievance redress mechanism or an operational grievance mechanism to ensure that the community are given an opportunity for quick responses to their concerns. Major projects are also required to set up a community consultation committee that should be established before the project construction occurs and must be maintained during the operation up until compliance to closure. The idea of engaging the community seems to be a very strong way of ensuring that environmental monitoring could be clearly identified, they can clearly be involved to make sure that breaches that cause harm to the environment or society can be rectified as quickly as possible. And finally, we've borrowed some of the work done by the New South Wales Department of Planning on the independent environmental audit, making them a part of the Environmental Compliance Commission certificate, that if it's required, the department and the ministry can require an independent environmental audit. And there's still the focus on self-monitoring, given that it is still a very new situation in Myanmar, that there is a requirement to notify breaches, and there are consequences if those breaches are notified. If we have the community involvement, it also means that the community consultation committee and the operational grievance mechanism can be able to function efficiently to ensure that those breaches don't become major breaches. As I say, this is a system that is still being implemented. It's still a work in process. But I think, as we all know as the EIA practitioners, that one of the things about EIA is it never stands still. We constantly learn, and the idea of improving enforcement and compliance can produce enormous benefits to communities, to the environment, and to projects. Thank you very much indeed for the opportunity to present tonight. And I'd now like to reintroduce Cheryl, who's going to be moderating some of the questions and discussions. Thank you very much.
It worked. Can you hear me?
We can hear you.
Okay, everybody, I encourage the whole team to please come back. Welcome back. So I have been monitoring the questions, and many of them relate to some of the prearranged discussion issues, so I'll weave all of that together. And then we'll get to more specific questions of individual panelists. So the first question that I wanted to tee up is the problem of unenforceable commitment language, commitments to mitigation, and so forth. The drafting question: who, how, when, and where, and what faces anybody that's trying to hold a project proponent accountable. And I'd like to first turn to Erica, and perhaps you can talk about that from your experience and what you've learned from that experience, and whether your national guidelines have been able to influence that at all.
Thanks, Cheryl. Yes, when we were drafting those indicative standard conditions that are available on the website, we spent a lot of time working with the legal team and the compliance team to work out exactly how we could word them. I went to a really interesting talk from one of the preeminent environmental lawyers in Sydney, and he said we can spend years on an impact assessment and you can spend so much time evaluating it and trying to get it right. If you don't get the conditions right and they don't do what they're supposed to do, and all the discussions we've had around this, you can't enforce it. So strong language is needed. You must do this, you must do that, rather than you should, or perhaps. Loose language like generally reasonable and feasible even are very, very difficult. So we put a lot of time and attention in trying to make them as clear as possible. One of the conditions, just because we have had discussions before about impact assessments, an impact assessment is always written far more loosely because it's a recommendation, and so there's lots of should and perhaps and maybes and probablys. But in actual fact, if you put a condition in that says you have to do everything that you said you were going to do, that even if you've got loose language in the impact assessment, it gets tied up through that language in your conditions.
Phil, what's your experience with this?
Thanks, Cheryl, and I agree with Erica. I used to actually manage the team that wrote our conditions. We have a separate team that write our conditions for our decision documents, and we had to turn our mind to every little aspect. And what I found with writing conditions is that every single word, no matter, depending where you place it, can change the way a proponent could interpret it. And when proponents see these things, a lot of times they look and say, okay, how do I meet this? So it has to be very clear. It has to be attainable. They have to be able to reach that goal. They have to be able to accomplish whatever you're putting in there. So we've worked closely, as Erica alluded to, with our legal folks and made sure that we're meeting what we need to within there. We use time bound, be very specific on what phase of the project these conditions need to apply to, geographically, if we have to, how far they need to go to. But we also have to, as part of our legislation that says these measures must be economically and technically feasible. So one thing we've done is we've actually worked with proponents, and we'll go back to them and say, can you please confirm that these are actually economically and technically feasible? Now, there may be some proponents that say, well, we can't do this and we need the justification why, but we want to make sure that before we finalize those conditions, we get a signal from them that says, yes, we can do this. And the sooner we start working with them on this, the better.
All that is all well and good. Many countries have tried to develop training. The environmental impact assessment documents are written by consultants to project proponents, neither of which has really been trained in the art of drafting enforceable language. And while there's been some hope that training consultants to do that might work, that's been a reach. And so I want to just flip this to Sebastian for a moment and have you all comment on this. To what extent might the formatting for whether it be the environmental management plan or the proposed mitigation, can the formats tease out the kind of specificity that you're looking for? It's sort of a backwards kind of pressure to get something more enforceable. And what are your thoughts about that, Sebastian?
Well, I think it's completely necessary to use standardized formats. It's easier for everyone. EIA team must facilitate the task for enforcing, and that means spreadsheets, tables. We need information in a very easy way to collect that. So we're doing that. No, the idea is it doesn't matter if the EIA document is written in with many words and prose style. No, then you can adapt that in a format. No, it's not necessary. You can do that later when the project is approved, but it would be better to do it from the beginning. So I think this is about communication, coordination between both teams. I know that there are some countries that include the same teams in one institution. In Chile is different. We have two teams, so it's difficult to get this instance for discussion and coordination.
Erica and Phil, and I'm going to get to Matthew in a moment, but about that. But who does the translation of a proposed mitigation or condition for approval and getting it into legally binding terms? Many countries without the kind of infrastructure for governance just rely on the document itself. And I understand that you have another step involved in the process.
Thanks, Erica. Yeah, for us, when the commitments come in from a proponent, we recognize, as Erica mentioned, that there's a lot of loose wording in there. They may say, if feasible, or if possible, maximize, minimize. So we take those commitments, we identify specifically which ones need to go into our decision document, and then we have a separate decision statement writing team. And so they'll take those commitments, they'll take those key mitigation measures, which we call them, and we transpose those, or we translate them, as you said, into legally enforceable text, which as we also work with our legal folks. We work with as well our compliance and enforcement team to make sure that they are in fact enforceable. And so there is that step there where we look at those things, we make sure we match all the criteria, targeted, technically economically feasible, clear in the sense that there are thresholds if needed, but also we want to be careful not to put officially induced error in there either. So we're very careful that we make the condition results driven and showing what they want, we would like them to achieve, as opposed to tell them how to achieve it.
Erica, do you?
There's always a table or a section in the impact assessments that get written or that we write in New South Wales, which actually is a compilation of all the mitigating measures. So in an ideal world, they're all there, but sometimes they kind of get lost in the context of the thousands of pages of impact assessment report and all the technical documents that come with it. But because of that, so if things are really important, they will get picked out. And it will be a condition that goes in that pulls something out and makes it a very definite condition. You may not go outside of this area. You may not knock down this building. But otherwise, there's a general condition that says you have to do everything you said you were going to do. So all your mitigating measures that you wrote down, you have to do them. And if the language is loose, it doesn't matter because it gets overridden by the you have to do what you said you were going to do.
I want to mention that this first discussion question really addresses something that Rob, I think it's Rob from the Netherlands, said. The need for data is essential, but so is getting approval license conditions right so they are actually enforceable. And that's what we've been discussing right now. Eric, and again, Matt, hang in there. We're going to get to you. I want to address for a moment the fact that if you are relying on the environmental impact assessment document, what happens when you have your inevitable changes to a project proposal? And this relates to my third area of questions, which has to do with the stage, which I want to get to. But and I want to ask this question of modifications also in terms of something Matthew Baird brought up when we were talking. He said, well, EIA is not really, we don't really think in terms of compliance issues. And I think that that's because of the stage of environmental law in many of the countries he's talking about. So if you have a set of laws and standards and conditions, and you want to make sure they will be complied with when you come in before a project, that's what we think about as a compliance focus. But for the EIA, the focus is compliance with the promises or the novel that they've written that you want to make legally binding and make it compliance oriented. So, it's a thought process for those people in countries where you don't have permits and you don't have standards and you don't have requirements per se. So they think that that's compliance, but this is a whole different animal. So can you please address that?
It's interesting because when you work as many of us have and certainly I know Phil has, in the space of writing impact assessments, your focus is on going, what is the proposal? What is the environment in which it's taking place? What are the impacts? And how am I going to mitigate them? And that is your focus. Your focus is going, there's an impact here, and how am I going to reduce or minimize or avoid it? You don't think when you're doing that about the enforcement side at the other end. You simply are going, there's an impact and I need to work out what to do about it and how significant it is or otherwise. It's the job of the people that sit writing the decision statements and things to take all that upfront stuff and go, okay, we now understand the impacts, we understand the mitigating measures. You've said you're going to do all of this, and you've said that by putting all these measures in place, you will reduce or avoid or minimize the impact. It's the job of another team to go and work out how to do it. I don't think most impact assessment professionals put that hat on when they're writing. I don't know, Phil or Cheryl.
I want to get to Phil in a moment, but I want to raise this in terms of multiple permits and so forth. One of the things that's very difficult to do, but we've been trying to do as a solution in the US, is to bring all the permitting parts, because they're really oriented to, aside from permits that look like you're allowed to do this, that's a permission statement, the ones that contain conditions, whether it's a decision document or not, the people who are responsible for that engaging earlier within the ESIA process, so that actually the citizens, when they are reviewing and commenting, can not only review, can that the permit people can get as much information as they can at that stage, which is not always possible, so that there's this carry through of what things will be followed up by a different organization. Now, in Chile, you have responsibility across all the government agencies. In Canada, a lot of the air and water enforcement is typically done at the provincial level. So that gives another level of, to what extent have you thought about incorporating some of these things into their permits so that they can follow up on some of those things and you don't have to look at the whole? So.
Yeah, no, that's a great question, Cheryl, and good points. And yeah, so where there are potential duplication or overlap in some of those requirements, we work with those provincial bodies to first off have them as part of our process to make sure that their interests are recognized. But we will also, under our new legislation, there's another change we have is that if there's another person or jurisdiction that's able to ensure that a mitigation measure is going to be followed, they can let us know in advance, and we'll basically remove that as a condition from our permit or our decision statement, trusting that this other body can handle that. They'll have to report back to us on how they've met that. But again, that's to try to avoid duplication, make sure that jurisdictions stay in their lane, so to speak. But we also have, to what you were saying, Cheryl, as well, is a planning phase now in our process. And this planning phase brings everyone in early so that we have a good idea of who's implicated, what specific permits, authorizations, certificates are required. And as I mentioned as well during my presentation, lifecycle regulators, so those bigger entities, we don't even technically need a decision statement being enforced because they're going to adopt all these things into their certificates, and their compliance and enforcement team will handle things.
Forgive me for this, I can't help myself. But if I were you, I would continue to have that condition and just indicate that this other institution's going to take the role. Because otherwise the whole of the EIA, it's going to be very difficult for anybody, any citizen or others, to follow up on that. But that gets to this formatting idea where you always have the problem associated with the mitigation or commitments associated with the monitoring and record keeping associated with an institution that's going to follow up, and that the mitigation have specific kinds of information, location, capacity, size, type of activity. But that may or may not solve all the problems. So let me ask a question that's also come from Songkrat Pangbu. The name got cut off, and you might know this person because I think it's a Thai name, but how each country deals with projects that have long life cycle to compliance. For example, how to ensure 25-year mining project to restore areas after they finish the project where the companies have no interest to comply anymore. That staging issue also comes into the fact that the EIA covers the life cycle of impacts, but sometimes the institutions responsible for follow-up, monitoring, and compliance only look at it through construction, and then it's another group that deals with operations. So can we talk about the staging issue and how we have a long time horizon, which challenges us as humans? You have to live long enough.
we have that problem in Chile as well. We have to do all that. We have to monitor all the phases of a project. And as I told you, some projects last many years, different phases. So I would insist that the key for this is to think about indicators for each stage. So in that way, we can automate all the process. It's so difficult to manage all this information and stages in the traditional way, no? I think we have to think in indicators and thresholds and commitments that we monitor in an automated way. I think that's the key, because otherwise it's so difficult. Doing that, our monitoring team can focus on the specific problems, incidents, and deeper analysis. For sure, human beings are so important in this, but we need to take advantage of the technologies at this moment. I think that is the key.
I'm going to come back to some of this. I'm going to mix it up a little so you all get a chance to talk. But a happy birthday from Vicky Bowman, by the way, Matthew. I'd like to ask you about what kinds of consequences, what have you learned from looking at the experiences across the globe that you built into the laws that you were helping the countries draft in terms of enforcement consequences? And I'd like you also, while you have the stage, to talk about grievance procedures and citizen monitoring and what role you see that playing. And then maybe everybody else can comment on what you say.
So first, in terms of impact assessment, EsIA, it is like it's followed now as a sort of a doctrine of international environmental law. The similarities are there, so we can learn from each other. The second thing, I think, as Sebastian pointed out, that we can use technology to essentially leap over some of the regulatory problems that countries have, such as Myanmar or Cambodia, where even though we have the system, the regulatory infrastructure just isn't there. But we can use technology, and then in some ways, those forms and that technology will influence our regulation. But the third comes back to community involvement. I think we're now at the stage when we have cell phones, almost universal mobile phone coverage, which is important, that things like operational grievance mechanisms, community consultative committees, paid for and supported by project proponents, are now going to be fundamental. Because if the project proponent want their license to operate, want to get their project through, the ultimate thing about enforcement and compliance is not to ensure complete compliance with all conditions. It's about to ensure that substantial compliance prevents environmental impacts or social impacts. And if they do, we have that feedback loop that we can rectify it during the course of these projects. And we all remember, as my last point, that our projects these days, the mega projects, are so much larger and so much more complex than we ever thought 70 years ago, that now we need all of these things to work together to minimize, not eliminate, but minimize their environmental and social impact. So that's the three. But ultimately, the role of the community, I think, is so fundamental going on that if we ignore it, we will lose all the benefits that we get from EsIA.
Yeah, I would agree. I think there's just I mean, when you look at the number of projects in Chile, for example, there's just no way that one organization can monitor compliance with all conditions across all projects at all periods of time. So using the community is essential.
And I happen to think that if we don't have the data systems working for us, it's virtually impossible for anybody to follow all this. And the transparency aspect of it is really important. In fact, one of the many comments, Kinyelwe Mushi, and I hope from South Africa, and I hope I'm doing justice to the name. What role can NGOs and conservation agencies play in ensuring compliance of approved EIAs to ensure that their efforts on environmental protection and biodiversity conservation doesn't go to waste, especially with government budget cuts on compliance officers' travel budget in South Africa? So that's very much related to what we're talking about.
I would like to say that citizenship and NGOs are so important because we need more eyes looking for compliance. We need technology, we need the community, and I think that's the way we need to facilitate information data for those institutions and for the citizenship, so they can use that data, that information, to push the limits.
Phil, I think that also reaches that other issue we talked about the intergovernmental aspects of this, because the transparency within a province will only happen maybe within the province, but there are so many other actors that are involved in environmental impact assessments and the crosswalk of similar types of projects. They all need that kind of broader access, even in transboundary access.
Yeah, they do. That's right. And we try to build relationship as much as possible with Indigenous groups or community organizations near our project. So as Sebastian said and Matthew mentioned, we want to make sure we have eyes and ears on the ground when we necessarily can't be. We're centralized in Ottawa, in the nation's capital, and we travel to all our sites. We can't be there year round. We can't be there for every milestone. So we try to benefit and leverage those relationships. And we're working to build those relationships now so that we can get those notifications, and we have specific measures in our conditions that require the proponent to communicate with and develop a notification plan process, so that if there is a grievance or is there a concern raised by a community member, there are steps to follow to resolve that issue.
I want to handle some. Do you think the form of the conditions or the commitments is important, or is it the language itself, as long as it's legally enforceable? For example, you have environmental compliance certificates in Myanmar, you have decision documents in Canada, you might have, it might be considered a permit in other countries. So is the form important, or to what all this means? Anybody?
I would
Caroline,
think the content.
I think the form is less relevant as long as there's words. You know, ideally in countries that have
numbers.
Like Cambodia, we've got proponents who are English, use English language or Chinese. The key is to have a document that sets out in some written form what is required, because issues of translation and also transformation onto the forms, as Sebastian said, you know, they are the key. I like Sebastian's. What's happening now is that the form is actually driving, or the compliance form is driving perhaps some of the conditions, so that those details, those specifics can be clearly recorded and they can find their way into the approval documentation.
This is why 2 webinars have featured some of that aspect of it, because I don't know how else you get there. Even though we have problems with hacking and quality and all of that. But so let me ask you this about third parties. And you mentioned, you know, who does the checking and how do we know? And there was a study in India where they had third party auditing, and they found that even with that, they needed a third party assigning the auditors. Otherwise, it didn't come out right when it was hired by the project proponent. So that's related to a question by Saeed Hamid. How do you ensure the veracity of data obtained from third-party labs, citizenship, public organs, etc.? Quality.
And Cheryl, this is Tanya, and I just want to say this has to be our last comment as we are wrapping up for the presentation, as much as I'd love to have the conversation continue.
Thank you. I'm sorry. We will address everybody's comments in our report. Please, quality, veracity.
So important, so important. I think we need to define standards for those third parties that ensure the data quality. I think that's the key. They need a fourth part. They need another organization to check if they are working in a proper way.
So in the independent auditing documents, that one of which was on that slide that I put in, there are all the requirements for who in actual fact may undertake an independent audit. And there's a lot there, that they cannot have a pecuniary or other interest in the project, that they can't have worked on it. So there's a lot of criteria, and also the requirement for auditors to sign a declaration. So we've been through that in New South Wales, and I think that independent auditing document that I put up on one of my slides probably might go to helping solve that particular question. I don't know, Matthew, I think you also referred.
I was going to say that you know, there's also technology. So in Singapore, they have 24-hour a day, 7-day-a-week monitoring using cameras that can detect emissions from factories. So if there is any emissions, they can then the satellite imaging that Sebastian showed can identify breaches outside. You can use big data now, working with communities, NGOs that also have access to these data sets to identify people that breach their cadastral boundaries, that go outside their area or clear forests or do things. So there are many technological ways to use best data that don't necessarily require that third-party auditing. But also, I think we have to take a leaf out of the business and human rights and the supply chain sustainability. At some point, there is a limit that to go beyond is going to create significant resources, regulatory resources. And again, that comes back to the advantage of community engagement, community compliance, that they can identify where the problems are, and then you can check the data, because the regulators are not going to have enough time or money to really check all of that information. So we do still have to rely on third parties, you know, making their certification, making their attestation.
I think I was overly ambitious. Maybe we needed 2 hours, and maybe we need to do this again. But we have so many good questions. I want to record what you know about enforcement consequences. How many actions have you taken? Have you succeeded? We will answer all the questions, and I will tell you that they are great questions to everybody. So without overstaying our welcome, I turn this back to Tanya. And Sebastian, if you will put up the ending slides. Thank you, everyone, for an excellent panel discussion and presentation.
Absolutely. Brava, brava. This is an amazing webinar with rich information. I think people were actively engaged through every minute of every portion. So thank you. Just a few closing remarks for you. You will receive a copy of the audio and video of this presentation, as well as the slides in a day or two. There will also be a brief survey as you're leaving, and it would be greatly appreciated if you would take the time to fill that out. Finally, and most importantly, many thanks to our amazing panel of experts today, and special gratitude to Cheryl for her vision and leadership in putting today's event together. Thank you to each of you for taking the time to expand your knowledge by the attendance of today's webinar. I wish you all a great rest of your day. Stay well.